Okay, for our next presentation, we have with us, first we have William Polk, who is the Assistant General Counsel of the North Carolina Department of Public Safety's Division of Emergency Management. His duties include preparing emergency and disaster declarations, communicating with FEMA and other federal disaster response agencies, and serving as legal liaison between the department and the Governor's Office for Emergency Management, Response, and Recovery. Will served as the chief legal counsel to the Office of Hurricane Irene Recovery in 2011 and has led a variety of other emergency management positions. He is a graduate of NC State University and NC Central University School of Law. We also have with us Jonathan Doerr, who joined the General Counsel's Office at the Department of Public Safety in June of 2018. He became the DPS Deputy General Counsel and Lead Counsel for the North Carolina Office of Recovery and Resiliency in March of 2019. He's a native of Pawleys Island in South Carolina and graduated from Presbyterian College with a BA in Political Science and then graduated from Emory for law school in 2012. He passed the Virginia bar and was a trial attorney in Charlottesville, Virginia. And he later passed the North Carolina bar and was a supervising attorney at SB2 Incorporated, practicing in the field of Medicaid, Medicare, and veterans benefits for residents and long-term care centers. And so thank you to both of our presenters.
How's everyone? That's good. That's good. Well, again, thank you all for having me here today. Look forward to talking with you a little bit about our disaster program overview as far as from the legal standpoint here in the state of North Carolina. So just to sort of set the table as far as what is the enabling legislation for our disaster recovery programs in the state. It is in the North Carolina Emergency Management Act, which is found in Chapter 166A of the North Carolina General Statutes. Basically, an emergency is defined as you can see, as an imminent threat of widespread or severe damage of loss or life, property resulting from any natural, man-made, accidental, military, etc. And that's triggered by either a declaration by the governor or General Assembly, or at the local level by either the head of the chair of the county commission or a mayor if the local government has delegated that authority down from the county level to the municipality. The emergency area is essentially the area described in the emergency declaration for what's covered under that state of emergency. And then for purposes of this discussion, a disaster declaration is a gubernatorial declaration that the impacted or anticipated impacts of an emergency constitutes a disaster of one of the three types that's enumerated in the Emergency Management Act. Again, as I mentioned before, the governor can declare or the legislature can declare that state of emergency. The declarations actually expire when it is rescinded by the authority that has issued it. So, for example, we just recently have Hurricane Dorian that hit the eastern part of the state, went up through the Outer Banks, and then went back out to the Atlantic. That declaration is still open. The governor has not formally rescinded it. So that's an example of where the state of emergency, even though the incident period was back in September, due to the ongoing needs of Ocracoke, that declaration is still staying in place. And the exercise of the powers under the Emergency Management Act is not dependent on the declaration of a disaster type. Once we don't have to declare it a disaster to continue to operate under emergency powers. So they're basically, to get into the disaster declaration that will be declared by the governor, there's basically two steps that has to happen at first. First, you have to have a preliminary damage assessment, and that damage assessment is done by local, state, and federal emergency management officials. And then that damage assessment is then turned over to the Secretary of the Department of Public Safety, who then provides that report to the governor and the General Assembly. The next step after that is done is the governor will declare a disaster, and under our Emergency Management Act, it could be classified as a type 1, 2, or 3 disaster. So a type 1 disaster is basically one that primarily the state is responsible for. And it mirrors the Stafford Act at the federal level as far as the types of assistance that individuals can receive when that gubernatorial declaration has been declared. The types of assistance is individual assistance and public assistance. And individual assistance, as it sounds, goes to individuals who have been impacted by the emergency event. And the types of programs that we have in our state level program that are comparable to the ones in the Stafford Act, provide temporary housing and rental assistance, repair and replacement of a dwelling, replacement of personal property, and you can continue, and you can see the other types of programs that are listed there. Public assistance is more for local governments whenever they have infrastructure damages, such as, and also obviously you have to clear debris, emergency protective measures, roads and bridges, crisis counseling, and assistance with public transportation needs. As I mentioned before, the programs are comparable to the ones in the Stafford Act. In order to trigger the Type 1 declaration, you have to have several factors to be met. One, you have to see that a local declaration of emergency has been declared by the local government and then sent to the governor. Then, if it's going to be a individual assistance Type 1 disaster, we have to meet, the preliminary damage assessment has to meet or exceed the Small Business Administration's disaster loan program for individual assistance. It can be met by one of 5 ways, and the most common way that for us here in North Carolina, how it's done is the criteria that at least 25 homes or businesses, or at least in a combination of at least 25 homes, businesses, or other eligible institutions have been impacted by the event. And each of those have sustained losses of 40% or more of the estimated fair replacement value or pre-disaster fair market value, whichever is lower. So, and then here's the criteria for public assistance. Unless you're representing a local government, this probably won't be relevant to you, but if you are, the criteria is that it must meet or exceed the state's infrastructure criteria for an eligible entity, and those eligible entities are listed in the Emergency Management Act. Typically, as I mentioned before, local governments or political subdivisions of the state, and also private nonprofit utilities such as co-ops are also eligible entities under the infrastructure requirement. Those uninsurable losses have to be an amount equal or exceeding 1% of the annual operating budget of that entity. The entity must have a hazard mitigation plan that has been approved by FEMA. The eligible entity also must be a participant in the National Flood Insurance Program. And then last, the eligible entities are required to provide a 25% match of the eligible costs for the public assistance grant from the state. And then last, the criteria for both IA and PA under our state disaster programs is that a Stafford declaration has not been declared by the president. How long do these disaster declarations last once they've been declared? So for a Type 1 disaster declaration, it expires 60 days after issuance by the governor or the General Assembly. And then it can be extended in increments of 30 days, but it can't exceed 120 days from the initial issuance of that disaster declaration. A Type 2 declaration is one that we most commonly think of when we have our larger storms. So Type 1s typically are very localized events. You may have flooding, a flood event. You may have even an event like what happened in Durham, for example, with the explosion of the in downtown Durham, when you had the coffee shop and other places that were destroyed by the gas explosion there. So that was another place where you had a Type State 1 disaster. So it truly is an all hazards type of state program. Type 2 declarations are when we start getting into the Stafford Act for when we have much larger events. So that could be your hurricanes, typically here in our state that we get Stafford declarations for. There are other types of natural hazards that we could get Stafford declarations, but typically it's been hurricanes. It's been a disaster that's been declared by the president, and the governor can then request that without making a formal Type 2 declaration, which as far as the normal course of business, that typically is how it works. As far as types of state assistance that may come under a Type 2 disaster declaration, there is the State Acquisition and Relocation Funds. So that program is a gap funding program. So whenever disasters have been declared under the Stafford Act, the state's eligible for hazard mitigation money under that federal disaster declaration. And those funds can be used anywhere in the state. They're not just limited to the area that has been declared under that Stafford declaration. So with that hazard mitigation money, the state, the SARF as it's called, people who are in I'll use flooding as an example. They may be in a special flood hazard area, and they need to be bought out. That's as far as an acquisition. So with the FEMA federal hazard mitigation money, we'll use a portion of that to buy them out. But sometimes when they relocate to another residence, that buyout from FEMA may not be sufficient to cover the cost for their new residents. So the state has this SARF program that will allow for a gap payment to fill that gap between what they got from FEMA and what the new house is. And under Hurricane Florence, the gap payment is $50,000. So that's what an individual can, up to $50,000, that's what they can receive to pay for that gap when they participate in the SARF program. And then also the supplemental repair and replacement housing grants are also programs that individuals can be eligible for under our state Type 2 disaster declaration program when there's been a Stafford declaration. The duration of a Type 2 disaster declaration is 12 months, and it can be renewed by the governor or the General Assembly. It can be renewed in increments of up to 3 months, but it can't exceed a total of 24 months. Then the last one is the Type 3 Type 3 disaster declaration. That's for the really major storms, thinking Matthew, Florence, Floyd prior to these two storms from the last 3 years. Again, that is when the president has declared a major disaster declaration under the Stafford Act. The preliminary damage assessment indicates that the extent of the damage is reasonably expected to meet the threshold for an increased federal share of disaster assistance. So typically, federal disaster assistance is state split and federal split is 75%, 25%. But in some rare situations, that cost share can go up to 90-10 federal, state, or even in some cases all the way up to 100% federal. So that will be one of the criteria to meet a Type 3 disaster. The other way is the damage assessment prompts the governor to call a special session of the General Assembly to set up programs to meet the unmet needs of individuals, businesses, and subdivisions affected by the emergency. So that's been historically the way that the state has dealt with Type 3 events. So after Hurricane Matthew, Governor McCrory declared a special session. After Hurricane Florence, Governor Cooper declared a special session of the General Assembly to trigger the Type 3 declaration. And again, the types of assistance under those programs are the SARF program, again, the supplemental repair and housing grants to locate people in a safe sanitary home. Those grants are up to $25,000. And then last, any special programs that the General Assembly may authorize in that special session. And with the various disaster recovery acts that we've had since 2016, there has been multiple special programs set up, not only for emergency management, but also other organizations like Golden Leaf and other state agencies that have a hand in disaster recovery. The expiration of a Type 2 or 3 disaster declaration does not impact the obligations of the state to continue Under the FEMA state agreement, the contract that the state signs with FEMA whenever we receive the Stafford Declaration, it continues even after, our obligations continue even after the disaster declaration may have expired. So as far as the federal side, I have already touched on them a little bit, but we'll go a little bit deeper dive into them at this point. The first, there's basically two,
I'm sorry, can you, on the state programs?
Yeah.
How are people applying for those?
About the,
You're getting to that?
well, I'll, as far as state programs, it's very similar to the Stafford program. So with the state program, what a disaster recovery center is opened up in the geographic area where the disaster declaration has been implemented. And then the individuals will first apply, since whenever the state program has been initiated, typically we'll also request the very first program that I'm about to discuss, the SBA program. And then, so people will then will apply for SBA assistance first, which is a disaster loan. If they qualify, they'll get the assistance from the SBA. If they don't qualify for the SBA program, then that's where the state program will kick in, and it is comparable to the Stafford Act IA program, which the total amount of individual assistance grant you could get is $35,500 is the current amount, which is adjusted every October 1 based off the Consumer Price Index. And so individuals can then, if they can't qualify for SBA, they can get the state program. And also if the SBA, in some instances where SBA doesn't fully meet their needs, or for there's maybe some unmet needs that SBA can't cover, then the state grant will also kick in for that as well. And so, as I mentioned before, there's basically two types of federal programs that provide assistance to individuals under the Stafford Act. There is another program out there for agriculture, but I didn't include that today. Just focusing primarily on individuals. The first is the SBA Small Disaster Loan Assistance Program, and then the second one is the Robert T. Stafford Act. Basically, the State Disaster Loan Program, I know it's a lot of information there. There are basically 5 ways you can get into that disaster loan program. The first way is the president declares a major disaster declaration under the Stafford Act, including individual assistance. That is the assistance to individuals in the household programs. Again, that program works just like our state program, where persons will apply for SBA assistance first, and then if they don't, then the FEMA IHP program will provide them assistance. Second, the president declares limited public assistance disaster declaration, but then a private nonprofit facility that may be eligible could apply for SBA assistance. The program guidance that I mentioned to you before that we use under our state program, where there's 25 homes or more that's been damaged, the governor can apply for the SBA assistance that way. The SBA can on their own make an economic injury disaster declaration. That's what happened with Doerr. And then there's also the economic injury declaration in reliance on a state certification. So those are the 5 ways that you can enter into the SBA disaster loan program. The types of SBA assistance that's out there is there's the home and personal property loan that allows for homeowners to apply up to $200,000 to replace or repair their primary residences. And again, all these programs are for primary residences only. So if you have a secondary residence, that will automatically kick you out as far as assistance under these programs. There's also the physical disaster loans. And basically, those loans can be used up to about $2 million to help repair various machinery and equipment for those economic injuries, the physical business losses that may happen after an event. And so when the SBA does their declaration, they will, in their declaration sheet, will actually list the various types of disaster programs that the eligible area can apply for, whether it's the home and personal property programs, the business fiscal disaster loans, or to economic injury disaster loans that are also helpful for small businesses. Whenever, but again, the way that the SBA program is implemented, either at the state or federal level, is you have to have a Stafford Act declaration. And basically, in order for a local or state government or territory or Indian tribe to qualify for a Stafford declaration, the governor has to request to the president the declaration, and that area has to show that the resulting damage and the effects of the damage exceeds the state's capabilities to respond to that event in order to qualify for and we need to qualify for federal assistance to help us get back on our feet after that major catastrophic event. As far as FEMA programs, one of the major ones that is utilized for survivors from events is the Individuals and Households Program. It's in Section 408 of the Stafford Act. It basically is not designed to make people whole. It's not a substitute for private insurance, but it is a program that is put into place to basically provide for temporary assistance to help people get back after a disaster has occurred. The current maximum amount of the assistance, as I noted before, is $35,500. It resets every October 1 to reflect changes in the Consumer Price Index. The types of programs in the IHP is the financial household assistance, which includes rental assistance, lodging expense reimbursement. So if you're displaced from your home and you need to stay in a hotel or a rental house, you can get reimbursed for that. Home repair assistance, and home replacement disaster assistance. So those are some of the programs under the IHP. Others is disaster housing assistance, where FEMA may provide direct housing services to eligible individuals, including who are unable to use the rental assistance programs. And then the other thing about direct housing, the temporary assistance, doesn't count against the maximum amount for individuals under the Stafford Act. So that's another benefit of the program. Other types of housing programs under this is the manufactured housing programs. That was used quite a bit under Hurricane Matthew. FEMA also under Hurricane Florence allowed for both the MHU program, but also reintroduced travel trailers back into the inventory for disaster assistance in Hurricane Florence for North Carolina. So those are some, since available housing stock in many areas that get hit by our state is not great, these programs are definitely utilized quite often when we have individual assistance Stafford declarations in eastern North Carolina. They also have multifamily lease and repair programs, and then in some situations, FEMA will also authorize permanent and semi-permanent housing construction, but that's not a program that's often used here in this state. Other types of programs under the Stafford Act include the mass care and emergency assistance. Again, that provides temporary sheltering assistance for individuals who have been impacted by the event. And also crisis counseling is another wraparound service that helps people deal with the mental health needs and other needs after a Stafford declared event. Disaster unemployment is another program that is authorized under the Stafford Act. In North Carolina, whenever we have a Stafford declaration and there's a trigger under our state unemployment laws that basically waives the wait period for applying for disaster unemployment insurance. So once that Stafford Act declaration has been declared, Employment Security Commission begins their process as far as implementing the unemployment disaster assistance. And then, of course, one that everyone in this room is probably very familiar with is the Disaster Legal Services, which is also a program that is authorized under the Stafford Act, under Section 415. And then last, disaster case management is one that has been used quite extensively in the last 3 years in our state under Section 426, which is basically provides a case manager for disaster survivors and helps them with their unmet needs and other long-term recovery needs. And that's another program that's authorized under the Stafford Act. As well, in addition to those programs, there's also the other needs assistance programs under the Stafford Act. As far as individual assistance, the programs I mentioned before are 100% federal. The other needs assistance program actually is a cost share between the state, 75%, 25%. But there's various types of programs that help with transportation and other things that individuals will need to use after recovering from an event. And also, there could be personal property assistance, there could be transportation assistance, moving and storage assistance whenever people are moving from one area to another. Other types of other needs assistance that is eligible under the Stafford Act is funeral assistance, medical and dental assistance is another program that's there, and also child care assistance is another program that could be utilized under the other needs assistance program under the Stafford Act. Last, as I close here, there has been, because of the Harvey, Irma, and Maria, there have been changes to the Stafford Act that really were needed because of the severity and the scope and size of those storms. And the Disaster Recovery Act of 2018, which was passed by Congress, resulted in over 50 changes to the Stafford Act and other federal programs. Some of those I wanted to highlight here is the duplication of benefit changes. One, typically when you have a disaster, people can't basically double dip. If you have a collateral source for recovery, you should utilize that. So, and Jonathan will touch on this some more with the CDBG-DR program, but one of the key things as far as under the Stafford programs that we always look at is duplication of benefit. And even with the SBA programs, we do that as well. So if you do have a duplication of benefit, it does count against how much you could receive as far as disaster assistance from the federal government. So one of the changes that, because of the areas of the country have been getting hit repetitively over the last few years, is that people may have gotten qualified for federal assistance from Storm X, and then Storm Y hits them a year or two later. That happened here in North Carolina. So basically, the governor now can make a request to the president to ask them to waive that duplication and the benefit requirement under the Stafford Act. And actually, we did send that letter for Hurricane Florence because we had people who were hit by both storms. The other thing is there's a state administered housing section. It gives basically allows for states to have more flexibility to come up with housing programs after a storm. It also expands the IHP program, excludes various restrictions on rental assistance and accessibility related to personal property costs to individuals. Another change to the program is it waives the debt waiver. So for people, if FEMA made a mistake in calculating their a person's assistance, and before FEMA will try to recoup those costs, but if applicant can show that FEMA was the wrong in making that overpayment, then that debt could be waived so that a person won't get hit again by FEMA's mistake. And then there's other provisions as well. Another one allows for the waiver of fees for when people may have lost their passports or other documents that are issued by the federal government. It gives the authority to those federal agencies where, like, if you need to go to the State Department to get a new passport, you don't have to pay the fee, or other types of federal documents that may have a fee associated with them. If it happened in a declared event and you can show that you lost it due to the storms, that those fees can be waived. So those are just some of the programs that were impacted by the Disaster Recovery Act of 2018. I put the link in there so you can see them. Many of them are in the process of being implemented, but some, like as I mentioned before, the duplication of benefit is in place. And another thing too that the act did was it went retroactively for some of the storms in 2017 as far as some of the increased benefits under the IHP program. It also allowed for people to get the benefit of that by backdating their the eligibility to 2017 prior to those three major storms that hit during that time period. So that's a quick overview of the state and federal disaster programs under the Stafford Act, our North Carolina Emergency Management Act, and our the SBA program. So at this time, I will turn it over to my colleague, Jonathan Doerr, from the Office of Recovery and Resiliency.
Good afternoon. Again, I'm Jonathan Doerr. I'm from the North Carolina Office of Recovery and Resiliency. You'll hear that thrown around a lot. It's NCORE, a sub-cabinet level agency of the Department of Public Safety. And out in North Carolina, y'all will more likely hear Rebuild NC. That is the program that NCORE runs. So if you hear anything about someone having an application with Rebuild NC, that's us over at NCORE. So got a few things that I wanted to touch on at the beginning to let you know what we're going to be talking about, at least what I'm going to be talking about for a little while. But I am keenly aware that it looks like I'm the only thing standing between y'all and cookies, brownies, and cupcakes. So I will be short so y'all can get to that. Will did a great job of doing an overview of some of the FEMA programs and state programs. Just as a quick, also wanted to give you a lay of the land above that. SBA, I think it was explained very well by Will and also earlier by Daniel and Leslie, so I don't think I need to go in anywhere there. And like Will said, there's FEMA, IA, and PA. So those three programs do a lot of the heavy lifting immediately after a disaster hits. I would also want to state that there is a fourth group of people or organizations that are instrumental in disaster recovery, and those are the VOADs. That's Volunteer Organizations Active Disasters, VOAD. They are instrumental in helping North Carolina recover, and they really do a lot of the heavy lifting right afterwards. And so for your clients who are looking to recover, I would state that they need to be going to the disaster recovery centers, looking at FEMA, IA, PA, looking at SBA loans, but also talking to the VOADs who can step in the breach where there is a lack there. My program that NCORE runs is CDBG-DR, which, like Leslie said, just rolls right off the tongue. But that is a HUD program, which is Community Development Block Grant Disaster Recovery. And so states, including North Carolina, have active CDBG programs all the time. That's a Blue Skies normally running program. When you add disaster recovery on the end of it, that adds the Stafford Act to it and all of those restrictions that come into place. CDBG-DR is a disaster recovery program that is meant to come once everything else has occurred. Every other form of assistance has been exhausted and you still have an unmet need. That's where CDBG-DR comes in response to a disaster. There are two other programs, though, that are considered what we call blue sky programs, which means they aren't necessarily tied to a disaster, but they are meant to help people who a lot of times they use these programs after a disaster. The first one of those is the HMGP program, which is administered by Emergency Management. And that is a long-term recovery and resiliency program, though you do not have to have any storm tieback to be in that program. Although if you were impacted by a storm, one of your applicants, they could have that repair work done through the HMGP program. They normally do buyouts and they do elevations of homes. So that is another program that your clients could avail themselves of. And then there is a brand new program, which is CDBG MIT. That's Community Development Block Grant Mitigation. We just got the Federal Register notice on that just a few weeks ago. And this is being administered by INCOR also. But you must have a tieback to some kind of disaster-related storm. But the funds used can help with repairs or construction that needs to be done because of a disaster. But CDBG MIT can also be for people who were not impacted by the storms. So if someone miraculously, their house, everyone around them were impacted by Florence or Matthew, but one person in that neighborhood wasn't, but through CDBG MIT funds, we might, if we're running a buyout program, we would also be able to help that person who did not have a direct storm tieback, because those funds are meant to be long-term recovery and resiliency, focusing on the resiliency part of that rather than necessarily the recovery aspect at some times. So those are a couple of different programs that the state is using both within emergency management and within INCOR. All right, so like I said, SBA has pretty much been handled, so I'll move on from that, except for to say, like has been stated before, and I think it bears repeating, that it being called the Small Business Association program, you should throw that out the window, because you do not have to be a business to get that money, like was stated before. So don't let any clients or yourself be fooled by the title of the agency that is tied to that. You do not have to be a business to get that money. And the second thing is that it is still a DOB pursuant to the Stafford Act, but you'll see there's a Federal Register notice citation there. The federal government did update their duplication of benefits policy, and it's in that specific Federal Register notice where some of this has been changed. All right, so currently these are programs that we have CDBG money for INCOR. Currently we have $236.5 million that was allocated to North Carolina pursuant to Hurricane Matthew. That is the only program that we can actually spend money from. We have been approved, we're the grantee, we have that pot of money, we can spend money off of Hurricane Matthew. We have, like I said, the CDBG MIT funds, which is mitigation funds. We've been allocated $168 million. The Federal Register notice just was dropped a few weeks ago, but we have not had our action plan or other things like that approved by HUD. Therefore, we cannot spend that money. It has been allocated to us. We are going to be able to spend it. We just can't yet because HUD has not given us the green light to do that yet. And then Hurricane Florence, we are currently allocated $336.5. Well, I shouldn't say allocated. We had a press release stating that we were going to get $336.5 million. That has not been finalized. We have not gotten anything. All we've gotten is a press release for Florence. So that's important to understand. So we have no Federal Register notice. We don't have anything written in stone on it. We've just gotten a press release from the federal government stating that they promise they're going to give us $336.5 million. And we should be getting, that should be the first tranche. There should be more money coming because originally when the large pot of CDBGR dollars was allocated by DC, that was before some of the wildfires happened in California, and some other disasters happened after that. And so some of that money got sucked into other disasters when they came up with a total figure. And so there is going to be a second tranche that they're going to try to bridge a little bit more of those unmet needs. So we are waiting with fingers crossed to find out exactly how much more than 336.5 we will get. I know y'all will look at this and see that it will cost a whole lot more than $236.5 million to recover from Matthew, and it will cost just gobs more than $336.5 to recover from Florence also. So this is not enough money to actually make North Carolinians whole, but it is what we have, at least promised at this point in time. So how do the CDBGDR funds work? Well, there's initially a press release. Again, that's all we have for Florence on that one. And then a Federal Register notice is released. And the grantee then starts writing an action plan, which is what we are putting together right now for mitigation funds, since that Federal Register notice did drop for mitigation money. And that obviously has been done for Matthew as that program is up and running. And we are trying where we can to sort of guess what the rules will be, and I'll get into this a little bit more later, what the rules will be for Florence, and trying to work some of that out right now. so that we can be ahead of the ball on that. Then there's a comment period for citizens based upon the action plan that is sent to HUD and approved by HUD. And HUD reviews that action plan, takes in the citizen comments. We have to respond to every citizen comment that is sent on the action plan. And then once HUD approves the action plan, then that is when we are allowed to actually start implementing the activities. And so again, all this happens after the Federal Register notice is dropped. We have to have everything approved. We have to have comment period. And then once HUD approves everything, that's when we can actually start implementing activities like opening up intake centers and doing things like that to actually start talking to the survivors of the storm. That third from the bottom one, DRGR access is granted, is important because this is getting a little bit into the weeds, but DRGR is basically the computer system that allows HUD grantees to talk with HUD DC. And so DRGR is the actual system that we send requests for reimbursement because CDBG-DR is a reimbursement program. So North Carolina has to spend the money and then ask for HUD to reimburse North Carolina for the money that's spent. And DRGR is the actual system that we ask for HUD to reimburse us. So it's, until DRGR access is granted, North Carolina is just spending money out of general North Carolina funds, hoping until DRGR happens so that we can have our coffers replenished by HUD. And so once the DRGR access is granted, then we can, again, start doing our draw requests. And then from that point forward, we're working off the action plan that was approved by HUD. And from that point forward, if we want to change the program at all, change any rules, reallocate money, do things like that, we have to amend our action plan. And that is done through either a substantial amendment or a non-substantial amendment. And the shorthand version of the difference between those is that a non-substantial amendment doesn't affect the services and money that the actual survivors get. But if we change funding or we change the rules, which might might lessen someone's available services or actually improve them, whatever it may be, those kind of changes to the program have to be a substantial amendment, and there's a lot more red tape that goes with changing the program in a way that will actually affect their survivors. It's generally seen as more inconsequential changes. Those can be done through a non-substantial amendment in which we just basically amend it and it doesn't have to go through approval by HUD, things like that. A substantial amendment basically goes back to the beginning, and it's sort of like the action plan. There's a comment period, there's approval by HUD, all those kind of things for a substantial amendment. And we are currently for Matthew under substantial amendment 5. So we're on our 5th substantial amendment, and I'm not really sure how many non-substantial amendments, but a few non-substantial amendments also on Matthew. And that is normal. Most programs, a lot of the bigger programs, if you talk about Louisiana, Texas, places like that would have $1 billion or more. They're looking at substantial amendments every 8 to 12 months. So you're constantly changing your program and updating it. All right, and so here's the funding process as it goes for CDBG-DR. This is what I said I was going to get to in a second. Congress approves this CDBG-DR appropriation. They calculate and they announce the allocation. That's what they have done for Florence so far. Then eventually they publish a Federal Register notice. That Federal Register notice has all the rules that we have to play by in actually administering that program as a state. And HUD, after they publish a Federal Register notice, ask us to show them that we have enough things in place to be able to run a program. We have to certify to financial capabilities, other things like that to HUD. And once they actually approve our certifications and state that we have enough infrastructure basically in place within the state agency that they believe we're able to administer the grant, then they actually sign the grant agreement with us. And that is basically the loan paperwork for $236.5 for Matthew and that sort of thing. And so it's once we sign the grant agreement, that sort of triggers the DRGR and us being able to move forward. Until we actually sign that grant agreement, we can't spend a dime of those dollars. And it is important to remember that this is not a federal program. There is no annual appropriation. There's no normal statutes that run that you would think of when you're thinking of money that you're getting from the federal government by way of a state like Medicaid or any other program like that. The statutory authority is pursuant to the special appropriation that is filed. And so in a default, the normal CDBG regulations apply. And then on top of that, you then look at the Federal Register notices, which then can change the rules, can do a complete 180 and completely say something opposite, and that would then be controlling. Or where nothing is stated, those Federal Register notices tell you what the rules are. And again, that last one there, reimbursement program, this is one of the things where the state pays for it first, and then HUD reimburses the state on those purchases. Included in that is the threat of recapture by the federal government. And so what that means is that HUD OIG is required to do an audit of every program at least once every 3 years, and there's other audits that occur also, especially at the closeout. After your entire grant has sunsetted, they're going to look at your entire program. And if HUD believes during an audit that North Carolina has done something inappropriate in whatever way, either gone too far with giving people more money than they were supposed to have, going too less, not following federal law exactly correctly, not following our own policies and procedures. So they hold us to the federal regulations, but they also look at what we write, our housing manuals, our action plans, things that we write if we're not following our own rules. Or if things are procured incorrectly, so if we do not procure our vendors and contractors correctly, things like that, then they can either, if it's before the money, they can just refuse to reimburse the state of North Carolina. And so that's something that we as attorneys for this program are always mindful of, because this money is not allocated in North Carolina's budget. It would be a really bad deal for North Carolina for those kind of things to happen. But also when they come in, say 3 years later, and audit the program, they can state, you did this X, Y, and Z incorrectly, and therefore we're telling North Carolina, you must send us back $20 million. And North Carolina's going to have to write that check and send it back to them after we've already spent the money. So this is something that we in the General Counsel's office are always wary of, and it's something that we really have to stay on top of. And that recapture not only applies to how we are running our program, but it applies to where the money actually goes. So for instance, if we have applicant Jones comes in, fills out paperwork, and we accept a certain form of ID for ownership or for something like that, a HUD OIG auditor comes in and says they don't believe that form of ID is actually legally viable and is not something that you should have accepted. Then what they'll do is they'll state, we're going to recapture these funds from you because you didn't follow your own rules, you didn't follow our rules or your own rules, whatever thing was broken in that. And on top of that, they also tell us you are obligated to recapture those funds from the applicant. So if they have had their house rebuilt, then we have to go back, and we are forced to go back and take the money back from that applicant. And if they're LMI, they quite likely don't have that money, so they would force us basically to use whatever assets, including selling their house from underneath them. And so that is why we are very careful with the way we write our things and the way that we administer our program, is we do not want to be put into that place where we fix someone's house just to sell it out from under them. That is something that we are always very wary of. And the stick that they have for us as a state agency is that failure to follow your own program during one storm might change your allocation for the next. So if you don't run Florence correctly, the next storm that comes, they may give us less money for the next storm because they don't believe that we can administer our program correctly, things like that. So these are things that we are always very wary of as we design our program and as we are administering it. That is why we are try to be as careful as possible when we're doing verification of benefits, duplication of benefits, things like that, because not only will we be hit, but we're going to have to go down to the actual applicant, and that is something that obviously we never want that to occur. All right, so eligible activities for this program. There is a focus on long-term recovery, and again, this supplements and fills gaps. It cannot supplant. So if there's another program, private insurance, FEMA IAPA, anything else like that, then CDBGDR funds cannot be used. It can only come in after the fact where there is an unmet need that cannot be met anywhere else. It must remedy a disaster-related impact, so there has to be a storm tieback. So if we're using Matthew money, there must be some sort of verifiable tieback to Matthew. If we're doing Florence, there must be a verifiable tieback to Florence. And we also must meet one of the 3 national objectives for normal CDBG. This is normal CDBG, not CDBGDR, but the CDBG funds is either the applicant must be low and moderate income, you must be trying to stop slum and blight, or there must be some sort of urgent need. Here is a good place to pause when we talk about all these different eligible activities. By the Federal Register notices, again, that's where all of our rules come from. We must spend at least 70% of all of our dollars on people who are lower moderate income. So at least 70% of every dollar spent you have to be able to show that 70% of those funds were spent on people who are lower moderate income. You can then have 30% or less. The 70 can get bigger, but it can't get smaller. Or 30% or less can go to those other two, slum and blight or urgent need. And also, the money, when they send down the Federal Register notice, not only do they tell you the rules in regards to how you write your policies and the actual amount of money you're getting, but they also tell you where you can spend it. They're going to name out the counties or areas in which these dollars are eligible to be spent. And they put those areas into two buckets. They're called, in the jargon within the industry, it's called mid and non-mid. Mid stands for most impacted and distressed. HUD is going to tell you, or what they believe are the most impacted and distressed areas. Normally this is done by county, although sometimes it can go down as far as zip codes. And 80% of all of your money has to be spent in mid areas. So mid counties, mid zip codes, that kind of thing. 80% of your dollars have to be spent there, and then you can spend, and that number again can get bigger, but it can't get smaller, and you can spend up to 20% of your dollars everywhere else. So for instance, in Matthew, again, that's the only one we have a Federal Register notice for CDBG-DR, we have 6 mid counties, and everywhere else is non-mid. So out of the 50 declared counties for Hurricane Matthew, we have to spend 80% of our dollars in 6 counties. 20% of our dollars, up to 20% of our dollars, can go to the other 44 counties for that disaster. And each storm is going to have its own Federal Register notice with its own allocation situation. And just for y'all to be able to keep all this going in your head, so we have the 70-30 for LMI that we have to do a balancing of. We have the 80-20 for mid and non-mid, and that is across all of the programs. That's across buyout, that's across homeowner rehabilitation and reconstruction, that's elevation, that's every program. So there's a constant, as you're doing intake and as you're spending dollars, you are constantly looking at the flow of dollars, where they're going, and figuring out where you're going to spend money to make sure you don't get on the wrong side of one of those balancing acts that you're doing for the 80-20 mid split or the 70-30 LMI. And so that would be and that's why in some areas, people who are in like situations, if they live in one place, we have to spend the money there because we have to keep that 80-20 and that 70-30 split. We always have to be mindful of that because if we get on the wrong side of that, that is one of the big places where recapture happens, where they go back to the state of North Carolina and would make us repay. Although I would say we are very proud. We have some vendors that have come in who are, have worked on a lot of the major CDBG-DR programs from Louisiana, Texas, other places like that are running these programs. And what we understand is that we are the only program that they've ever run into, and they've been in several, where we are well on over the 70% threshold for LMI. That is something that Rebuild NC and NCORE have so far been doing a very good job of working with that. Most programs have a problem getting to the 70. They spend a lot of money on slum and blight or on urgent need, and then they're trying to make up on the LMI on the back end, but we are well above that line right now, and so that's something that we're very proud of. All right, here are the Federal Register notices that pertain to Hurricane Matthew. They're there. You can read them. They are bland, and if you need to go to sleep at night, I would recommend reading Federal Register notices. But they are the rules. And every time they put out a new Federal Register notice, they can change the rules any way they want to, and it just completely upends the system. And we have to follow the rules until a new Federal Register notice comes out, which changes the rules. That last one there at the very bottom, 84 FR 28836, is one that I would encourage y'all to turn your attention to as you are working with your clients. That was a duplication of benefits update for the storms, including Hurricane Matthew, that we and other grantees had been lobbying HUD to change some of these rules to make it easier to get money to applicants, including this is where the SBA rules changes for DOB came through. This is one of the things that we've been harping with our HUD contacts about trying to get those rules changed, and they finally did change that in that Federal Register notice. And so that's a really good one when you're trying to figure out a way to help your client if you're talking about CDBG-DR dollars. All right, for mitigation, there's only one of them, and it just came out recently. That is the register notice for mitigation. That one, I talked about the 80-20 split and the 70-30 split for mid and LMI respectively. Again, this is one of those things where as soon as the Federal Register notices, you don't know what's going to happen. We assumed we were going to have the same sort of balancing, but lo and behold, it was a surprise when the Federal Register notice dropped and we got to look at it. They made it a 50-50 split across both. So that they named mid counties in that one that we also have to spend our mitigation money in, and they also talked about the LMI, CDBG national objectives that we have to follow, only they changed that weight to 50-50 for both. And it's written in a way that this is part of the reason why we're currently drafting the action plan, but things are we're trying not to get too far ahead of ourselves because it was written in a way that the Florence mid designations for the upcoming Florence Federal Register notice, whenever that occurs, those will be mids for CDBG mid. So that was written into that Federal Register notice. So we know what the Matthew mids are, but we do not know what the Florence mids are. And so before we can actually finalize our action plan for mitigation, because we don't exactly know where we're supposed to be spending that money, we're sort of waiting for that Florence Federal Register notice to drop so that we can design, so we know the rules for our Florence program, which can be different from our Matthew program. That's important to understand that these are two separate programs, even though they're administered by the same federal government. One can have different rules than the other because they'll have different Federal Register notices. But so we're also stalled on mitigation because we're not exactly sure what our mid-counties are yet for mitigation. Again, Florence doesn't exist. Just got a press release. And so we are still waiting on that with bated breath. And again, all right, so questions. Again, I know that y'all got cookies and brownies after this, but if there are any questions, I'm happy to answer them. Yes, ma'am.
I still don't understand how people are intaking and applying. Everybody knows how to go to FEMA. Everybody knows how to go to SBA. I still don't get how people get to all.
Well, it depends upon which program they're going to. I mean, we are CDBGDR. We're Rebuild NC. We have our own intake centers, which if you go to our website, rebuild.nc.gov, you can see where all those different intake centers are. We have some of them still open, although we are not accepting intake at this time because our Matthew intake ended a while ago since that program's been out there. We cannot do intake yet for mitigation. We cannot do intake yet for Florence, but we still have our intake centers open because that's a place for people to go to be able to speak to a caseworker, to speak to people about their Matthew program if they have questions for that. But there are no intake centers for Florence yet because we can't do anything with it.
How will people know if they should go, where to go?
There,
What it is? I mean, everybody kind of knows that
Yeah.
what FEMA is, but
I can't answer that question because I don't know what it is yet because we haven't gotten the Federal Register. We literally don't know the rules by which Florence is going to be done. We can't write our action plan. We can't write our housing manual. We can't write anything because we don't know what rules HUD is going to put on us. We have been asking them. We have a conference call with our HUD representative every other week and sometimes more often than that. And we are constantly pestering her about trying to find out what the Florence rules are. And they are tight-lipped. They will not let us know anything. So we sort of have an idea. We're guessing because the data that they use to determine mid-counties is FEMA data. And so the unmet needs assessment that FEMA does is what HUD uses to designate their mid-counties. So we have an idea. We have what we think will be the mid-counties for Florence, but we don't know yet. We also don't know what extra curveballs they're going to throw at us, which routinely happen in these Federal Register notices is you can design your program based upon, the way that it was written for Louisiana, say. And then the Federal Register notice drops, and they've done something that they've come up in DC that they believe is a great new idea for CDBG, and then now there's a brand new set of rules that are in the Federal Register notice. So as far as telling you how to help people who have Florence, damage, we can't do intake. If they were only impacted by Florence, if they were impacted by Matthew and Florence, then we did talk to DC, and they gave us a waiver to be allowed to fix not only Matthew damage with Matthew money, but if they were impacted by both Matthew and Florence, we can fix all of that damage. Because as it was written at the time, if someone was hurt by Matthew and Florence, the way it was written, said that we could only fix the Matthew damage, but we couldn't touch the Florence damage. We weren't allowed to use Matthew money on Florence. So, if half their house was destroyed by, Matthew, and also we would then have to be able to figure out, you talk about those forensic engineers, figure out what damage was from what storm and only fix part of that. That was the rules that they gave us, and we obviously lobbied them and said that this doesn't work. This is a horrible rule. And so they eventually dropped one of those Federal Register notices. I can't keep them all in my brain, but one of those changed that rule and said that you're allowed to fix Florence damage. So if someone was impacted only by Florence, we can't help them yet. But if they are impacted by both Matthew and Florence, then we can help them and fix all of their damage. We don't have to just do Matthew anymore. That rule did change. The other big rule change, that was the first one that happened. The second one was that SBA originally. When people were going into the disaster recovery centers trying to get FEMA IA assistance, they were being told to apply for SBA to see if they could get assistance through SBA. If they got assistance through SBA, they were given an award letter for, say, a loan of $20,000, then that entire $20,000 was counted as a duplication of benefits, regardless if they only accepted $10,000 or if they didn't accept any of it. If they were given a line of credit, that was considered a duplication of benefits. And so that really hamstrung a lot of Matthew people, because there were people who were either, they didn't want to accept a loan because they were worried about having to repay it, or any other reason that they may have had for not accepting that SBA loan. Even if they declined it, that $20,000 was put on as a duplication of benefits for CDBG-DR. We lobbied HUD on that change, and that was that last Federal Register notice where they finally accepted our argument and said, okay, if you've said that you've declined that SBA loan, then it's not a duplication of benefits, as long as you can sign an affidavit that says, I am not going to touch that line of credit, I'm waiving it altogether, that sort of thing, then that will no longer be counted as a DOB. That was the other big change for our program as far as policy-wise. That was finally accepted by HUD. All right, thank you all very much. Enjoy the brownies and cupcakes.